A very good day to Doctor. We are from Group 2, and today we will be presenting the case analysis for MGM 3313 Business Law, focusing on the legal dispute between Ketapang Trading Corporation and Jebas Sdn Berhad. Before starting, my name is Siwei Hong. My matrix number is 69928. For the introduction, this case centered on a 5-year, 150 million ringgit supply agreement for semiconductor components, entered into as part of Malaysia's EV Regulation 2030 initiative. The dispute raises several legal issues, including the formation of the contract, the enforceability of its term, possible breach or misrepresentation, and the remedies available under Malaysian law. To examine these issues, we have applied the ILSC method, which is issue, law, application, and conclusion. The analysis draws upon key Malaysia acts, such as the Contract Act 1950, the Sale of Goods Act 1957, and the Consumer Protection Act 1999, supported by relevant case law. Moving to issue 1, the contract formation. This issue is focusing on whether a valid contract was formed between Ketapang and Jemba, considering if the request for proposal and memorandum of understanding constitute offer and acceptance, and whether the agreement was properly authorized. Under Malaysian law, as outlined in Section 10 of the Contract Act 1950, a valid contract requires an offer, acceptance, intention to create legal relations, and consideration, with a clear distinction between an offer, which is a defined proposal to form a contract, and an invitation to trade, which merely invites negotiation without legal commitment. In this case, Ketapang's request for proposal is likely to be an invitation to trade, not a legal offer. This aligns with the case of Pharmaceutical Society versus Bots, where the display of goods was treated as an invitation for customer to make offers. Ketapang's RFP merely outlines specification and pricing expectations, inviting proposal from the suppliers. Jemba's MOU, which include a 10% price increase and modified delivery terms, is treated as a counteroffer rather than acceptance. This follows the principle in Hyde versus Birch case, where a counteroffer terminates the original offer and no contract was formed. Furthermore, even though the contract was signed eventually, its validity is questionable because the regional operation director of Ketapang may not have the authority to execute agreement exceeding 30 million ringgit. Under contract law, acceptance must come from someone with the proper authority. If not, the agreement may not be legally binding. The analysis shows that no binding contract was formed, as Ketapang's RFP was merely an invitation to trade, and Jemba's MOU act as a counter-offers. Additionally, the agreement was signed by a possibly unauthorized representative, making the acceptance invalid under Malaysia contract law.
Salam Sejahtera Doctor, my name is Ting Hua Po, matric number X69933. Now I present issue 2. The validity of the contract. The issue arises because the signatory lacked board authority and there was blackmail targeting the CEO before the signing. This arises the question of whether the contract is void or viable due to lack of consent under the Contract Act 1950, especially the Section 135 and Section 50. This situation is similar to the case of Barton Watson Armstrong. Moving to the application, Ketapang Regional Operation Director signed a 150 million contract, even though his authority was limited to 30 million. The contract will be valid if was later ratified by Ketapang. Since Ketapang continued with the contract for 40 months, this might be seen as ratification. In addition, the CEO claim of blackmail before signing arises the issue of duress. The case of Barton versus Armstrong. The court ruled that a contract signed under pressure could be void. In this case, if the CEO does not enter the agreement freely and voluntarily, the contract might be void due to lack of consent. However, since the CEO did not report the blackmail for the 6 months and company performed under the contract without any protest, The court might determine the Ketapang accepted the contract through this action. Conclusion: although the Ketapang representative lacked actual authority, Jemba Sendirian Berhad reasonably rely on his apparent authority, making the contract apparent legally binding. Well, the CEO blackmail claim could have made the contract void. The delay in reporting and continued performance indicate acceptance. Under the Malaysia contract law, the contract is likely valid and enforceable as the insufficient evidence to prove a coaction or lack of consent.
Salam sejahtera doktor, my name is Syed Alwin, my number matric is S70991. Now I'm going to present issue 3, terms of contract. Whether the key contract terms like delivery, quality and exclusion clauses are enforceable or not. The law we use in this issue is Sales of Goods Act 1957, Section 15 and 16, which related to the description and fitness of the goods. This act stated that exclusion clauses must be reasonable which comply with the public policy. The case law we use in this issue is Gamer versus Austin, which regule terms unenforceable. This law applies to the issue when the contract delivery clause unclear, which can be seen through seasonal consideration written in the contract. Next, the law also applies to this issue when Jemba Sdn Berhad provide a quality misrepresentation because Jemba claims that their components would be capable of operating between negative 40 Celsius to positive 125 Celsius, which has not been tested. As a result of testing, their components would only be capable of operating between negative 20 Celsius to positive 101 Celsius. Both of these situations have shown that the exclusion clauses are likely invalid under public policy. As a conclusion, the contract's terms are unclear, which would possibly unenforceable, and Jamba Sdn Berhad is liable to this case, while Ketapang have the rights to void the contract under Malaysia contract law. That's all from me. Thank you.
Good day everyone, my name is Minjay with number metric S70751. I will present about breach of contract. The issue is did Jemba Sdn Berhad breach the contract? Under Section 57, Column 2 of Contract Act 1950, which a contract to do an act which, after the contract is met, become impossible or by reason of some event which the promisor could not prevent, unlawful, become void when the act becomes impossible or unlawful. Jemba Sdn Berhad failure to supply the 50,000 specialized microprocessor during monsoon season when the factory caught fire because of lightning streak, but there is no express force majeure provision in the contract, so cannot be absolved of liability on this account. Next, Jemba Sdn Berhad non-delivery and combined with poor risk control legally seen as them refusing or being unable to perform. According to Section 40 of Contract Act 1950, if one party refuses or is unable to perform their promise, the other party may treat the contract as voidable. This situation is supported by the case Hong Kong Field Shipping Company versus Kawasaki Kisen Kaisa, where a serious delay amounted to a breach that went to the root of the contract. Next, Jembas Jan Berhad claimed that their component could be capable of operating between negative 40 degrees Celsius to positive 125 degrees Celsius, but internal report subsequently showing tests ranging from negative 20 degrees Celsius to 101 degrees Celsius. Under Section 17, Fraudulent Representation of the Contract Act 1950, where the company makes false representation of a material fact to induce Ketapang Trading Company into contract, as in case Dairy versus Pig. Knowingly making false claim to induce a contract is fraud, and the innocent party is entitled to rescind the contract or claim damage. In conclusion, Jumba Sendirian Berhad committed fundamental breach and misrepresentation, so Ketapang Trading Company may rescind and claim damage.
My name is Tarmina. My metric number is S70812. Let's begin with issue 5. The main legal question is what remedies are available to Ketapang Trading Co. following Jambal Sendirian Berhad breach for a contract and alleged misrepresentation. Ketapang suffered major losses, a cancellation of 25 million ringgit distribution deal, 7.9 million ringgit in liquidity damages, and damage to its business reputation. There are also the question of whether exclusion clauses can shield Jambal or whether they are void due to the unfairness of public policy. Legal analysis under Malaysian contract law, Ketapang may seek several remedies. Firstly, compensatory damages under Section 74 of the Contract Act 1950 to restore financial losses, restrictions and damages for misrepresentation of under Section 17 due to the false claims about the product's specification. Furthermore, contract termination under Section 40 for failure to perform a key obligation, restitution under Section 66 requiring return of the benefit under voidable contract. Under Sales of Goods Act 1957, Section 15, 16 and 37 give the right to reject goods that don't meet description or fitness of the purpose. Now, let's apply with the law in Ketapang case. Jambal's failure to deliver the microprocessor directly led to the Ketapang losing its 25 million ringgit annual contract and having to pay 7.9 million ringgit to affected clients supported by Hedley versus Bezendale. That falls under Section 74 as damages arising from breach. Misrepresentation over the microprocessor's capabilities gives ground to risking the contract. Jambal's failure to deliver supports contract termination. Ketapang can also seek restitution for any benefits conferred. While specific performance is unlikely, injunctive relief may be possible to prevent further misrepresentation. Lastly, the Sales of Goods Act supports rejection of the defective goods had they been delivered. Further conclusion, Ketapang has strong legal ground to claim compensatory damages, rescind the contract and pursue statutory remedies under the Contract Act and Sales of Goods Act. Malaysian law offers comprehensive protection for the losses they suffered due to the Jambal's breach and misrepresentation. To conclude, this dispute between Ketapang Trading Co. and Jambal Sendirian Berhad highlights key legal challenges in high-value commercial contracts, especially those involving government-backed and cross-border transactions. Our analysis identified several issues including unclear contract terms, procedural flaws, misrepresentation, and a major breach of contract. Applying Malaysian laws, including the Contract Act 1950 and Sales of Goods Act 1957, it is clear that Jambal is likely a breach and liable for misrepresentation. Ketapang has strong ground to seek remedies such as contract rescission, compensatory damages, and other statutory reliefs for financial and reputational losses. This case reinforces that need to clear contract terms, proper execution, and transparency in negotiation. Malaysian law provides strong protection to support fair outcomes in commercial disputes. Thank you.